Good afternoon to Sandy. Good afternoon to all. And thank you to Sandy for having me for your amazing class today. I am pleased to share a session with you for this semester. And by way of introduction, my name is Supari Noi. I am a Cambodian lawyer and a senior associate at Soxipana and Associates. I am here today to share with you my personal reflections and knowledge of fair trial rights at the ECC. And here's a bit of background on myself. And I would like to start the session with a few questions for thought, which I will read through for you with a small pause to allow you to reflect it by yourself. So we start with the first question. Why people bring case to the court? Next question. Why do we need lawyer to represent us at the court? Next question is, what are the main purpose of fair trial rights? And the last question, what does the ECC mean for the Cambodian legal system? The presentation today will start with the brief summary of brief introduction to the ECC, its establishments, its jurisdictions, and the cases before the ECC, and the role of the defense in the ECC. And I will also touch a little bit on the key procedural aspects of the ECC. And the next point was is the views and the views on benefits and drawback of the ECC. So I would like to first start with the introduction to the ECC. What is the ECC? When you hear the word ECC, what comes into your mind? The ECC stand for the extraordinary chambers in the courts of Cambodia. It was established by the agreement between the UN and the royal government of Cambodia, and it took the UN and the government, the Cambodian government, 10 years to come to an agreement to establish this tribunal. The reason why it took that long is because the UN and the government, the Cambodian governments, have to discuss what would be the mandate of the ECC and what would the Cambodian get from the ECC and what kind of people who would be brought to trial and what would be the nature and the structure of the ECC. So after the negotiations concluded, it was decided that the ECC should be function as a hybrid court, which include the national and international components, for example, judges, lawyers, prosecutors, legal teams, as well as the administrative staff. It means that the ECC is composed of 50% of the Cambodian personnel and the 50% of the international personnel. And as I said earlier, the ECC was established by the Cambodian government, the UN and the Cambodian government agreement, and the law on the establishment of the ECC. And the ECC is procedurally guided by its internal rule, which was adopted by the plenary of the judges, complementing the law on the establishment of the ECC. And it follows international criminal procedures applied mostly at the International Criminal Tribunal. And I would like to open a bracket here. At the time of the establishment of the ECC, the Cambodian government was still drafting the criminal code and the criminal procedure codes, and therefore the internal rules was adopted and designed in a way that it would somehow give detailed guidelines to the ECC, um, how to apply, and how to move and how to work on the case at ECC. Unlike the domestic court, the ECC structures has only two levels, which is the trial chamber and the Supreme Court chamber. But the pretrial chambers exist to hear pretrial appeals by the party. And in every level of the chambers, it requires super majority decisions of the judge sitting at each level. And the ECC was established to try only two groups of peoples. First is the senior leaders, and second is the most responsible persons. And the ECC will try only the crimes that were committed during the democratic Cambodia, which take place from 17 April 1975 to 6 January 1979. And please note that Democratic Cambodia is an official name of the Khmer Rouge regime. So you would hear here and there the DK, the Democratic Cambodia, or the Khmer Rouge, but they both are the same. And the ECC would try only just a bunch of national and international crimes, such as genocide, crimes against humanity, and ground breaches of Geneva Conventions, for example, war crimes, and the violation of the 1956 Penal Code, namely the premeditated homicides. And the reason why the 1956 Penal Code was used in the ECC is, like I said, because the Cambodian criminal code was still in draft at the time of the establishment of the ECC. And since its inception, there are four cases at the ECC. The first case is called Case 001, with the accused Kang Gek Il alias Duch, who was a former chief of S21, which is the Central Security Prison. And the case against him has completed, and he was convicted of the crimes against humanity committed under his criminal responsibility at S21 prison, and he was committed to life imprisonment. And during the trial, he was detained at a detention center attached to the ECC. However, after the appeal judgment, he was transferred to the national to be detained at the national prison, which was created to follow the UN standards, to follow the minimum international standard of detention center. And unfortunately, he died in prison in September 2020, a few years after he was transferred to the national prison. And he died of natural cause. And the next case we have after case number case 001, there was case 002, and in case 002 there were four accused. The first one is Mr. Khieu Samphan, who was the former head of state, and second is Mr. Nuon Chea, who was the former Deputy Secretary General of the Communist Party, and he was also the head of the People Representative Assembly, and he was famously known as Brother Number Two. And again, unfortunately he died during appeal stage in August 2019. And the third accused was Mr. Ieng Sary. He was the former Minister of Foreign Affairs, and he died during trial in 2013. And the last accused is Madame Ieng Thirit, who was the wife of Mr. Ieng Sary. She was found unfit to stand trial in 2012, and she eventually died in 2015. And in case 002, because of the complexity and the big scale of the crime sites of the charges in case 002, and given the fragile and the old age of the accused, the court has decided to severe case 002 into two, which is case 001, case 002/1, which is now complete. And while the case was going on, there were only two accused remain. The first one is the head of state, Mr. Khieu Samphan, and the second one is Mr. Noon Chea, who was the chief of the assembly during the Khmer Rouge regime. And as you know, that Mr. Ieng Siri and Madame Ieng Thirit died during the trial, so their case was closed. And case 002/1 appeal judgment was pronounced in 2018, and it found that both Noon Chea and Khieu Samphan were convicted of crimes against humanity in relation to forced transfer of population from city to provinces, and they were sentenced to life imprisonment. And in case 02/2, this case concerned the charges against Noon Chea and Khieu Samphan on crimes against humanity, which is in a bigger scope because case 002/1 only cover a small portions or element of the crimes against humanity. And so in this phase, this case 002/2, he was tried with again crimes against humanity, but in a bigger scope. The scope that were not covered in case 002/1, and they were charged with genocide against the Cham Muslim and the Vietnamese ethnicity, and the ground breaches of the Geneva Convention of 1979. And for this, the second phase of the case, um, there was a trial judgment in this case in November 2018, and the trial chamber found that Noon Chea guilty of crimes against humanity, genocide on Cham Muslim and Vietnamese ethnicity, and ground breaches of the Geneva Convention. However, the trial chamber only found Noon Chea only guilty of crimes against humanity and genocide on only the Vietnamese ethnicity, and the judge did not find him guilty of genocide or on the Cham Muslims at all, and he was found guilty of the ground breaches of the Geneva Conventions. And both accused were sentenced to life imprisonment, and the judgment was appealed. And during the appeal stage, Noon Chea died before the appeal judgment. And this year in September, the Supreme Court chamber has issued the summary of the appeal judgment, and which it confirmed that Khieu Samphan committed the three crimes above, and the full judgment is not yet available at the time of this presentation. And apart from that, there are also three more cases in the pre-trial stage. There was case 003 and case 004. And actually in case 003, there were originally two suspects. The first one is Mr. Miamut, who was the chief of the Navy at the southern part of Cambodia in a coastal area. And another person is Mr. Sumet. He was also the military commander, but unfortunately he died before he died during investigation. And in case 004, there were originally four suspects in this case. However, because the three suspects in this case have a different responsibility in different area, and there was a different characteristic of the charges against them. the court have severed the case into three different cases. The first one being case 004/1, uh, which has a suspect named Madame James. And the second one is case 004/2. And the suspect in this case is Mr. Ao-an, and he died in November 2020. And the third one is Mr. Jumtet, who remained in case 004. And a few facts of these three cases. The three cases concerns or share similar procedural development. I will just give you the quick summary, the quick summary of the three cases. Of course, three cases, they have different charge and different crime side, there were different elements of the crimes. But however, procedurally, this case is very unique in the history of the ICL. They both of the prosecutors for both of these cases did not agree on the charge. There was actually a split of opinion between the national and international prosecutor and also judge and investigating judge at the ECC concerning the certainty of this case or the future of this case. So both co-prosecutor did not agree on the charge, and which means that the international prosecutor found that there was enough evidence to bring the case against the suspect. However, the national prosecutors did not find that did not agree on the assessment of the international prosecutor. And with the case being a limbo for a few years, eventually the international prosecutor appealed the disagreement or bring the disagreement to the pretrial chamber. And the pretrial chamber judge was seized of the appeal from the international prosecutor. However, the pretrial chamber judge did not reach the supermajority decision to decide on the appeal, and therefore the international prosecutor's submission stands. And therefore, the action initiated by the international prosecutor stands. And then the international prosecutor issue an introductory submission to the and forward the case to the investigating judge. And again, the investigating judge did not agree on the charge. And after many years of investigation, eventually both judges issued the closing orders. However, there was again the split of the position of both judges, and therefore the national co-investigating judge issued a dismissal order, while the national co-investigating judge issued an indictment, but failed to forward the case file to the trial chamber. And with this, I would like to highlight that for these situations, I think it is again a unique. It makes a unique history in the international or the ICL, that the judge in one chamber issued two decisions at the same time, and we don't know and therefore there were no precedent for the ECC to consult with, or how they're gonna go around with this kind of situation. And with the split of decisions and the two closing order coming into force, coming at the same time, the international prosecutor filed an application to the trial chamber based on the international investigating judge indictment. And the trial chamber was seized of the appeal from the international prosecutor, and the trial chamber denied it was seized of the case because the case file has never been forwarded to it, and procedurally, when the investigating judge issued the closing order, either indictment or the dismissal order, the judge have to forward the case file to the trial chamber if the judge wants to send the case to trial, or the judge have to seal and archive the case file if the judge consider the case dismissed. But in this case, in this particular case, both judges did not carry out the necessary action post their closing order, and therefore the trial chamber denied that it didn't have the authority on the case, or that it doesn't have the jurisdiction on the case because it was not seized of the case file. And also the court management section could not could not either could not seal or archive the case file. And with this trial chamber decision, the international court prosecutor appealed the trial chamber decision to the Supreme Court, and eventually the Supreme Court issued a decision to terminate the case before both cases before the ECC due to the absence of the definite and enforceable indictment or enforceable the enforceable indictment. And the next part I'm gonna discuss on the role of the defense before the ECC. As you know that for the a society to administer justice in a legitimate manner, it must uphold and protect the principle of justice, and therefore the participation of defense is compulsory in any criminal proceeding, because first it protects the right to fair trial, and second it prevents a miscarriage of justice. As you know, like perhaps one of the greatest affronts to our perception of justice is the finding of an innocent person guilty of crimes he or she did not even commit. And the next reason why we need a defense is to show the society's commitment to justice rather than revenge, and to promote the respect of law and the rule of law. And the defense is important because it is part of the searching for the truth process, and because justice means both sides got equal chance to speak and present the story of their case from their side, and to challenge the evidence of the allegation from the other side, which in a larger extent is to promote the non-violent coexistence in the society by creating a new identity of the people or of the survivor. The last one is the defense is a necessary process to make the court legitimate. Because justice is not only about conviction, justice can also be an acquittal and finding of innocence, and to find understanding of the situation to both parties so that they can accept it and they can move on. And now I would like to focus on the fair trial rights. There is this common principle which was enacted or annexed to any domestic system, is that everyone is entitled in full equality to a fair and public hearing by an independent and impartial tribunal in the determination of any criminal charge against him. And As we may be aware that fair trial rights have derived from Article 19 of the Article 10 of the Universal Declaration of Human Rights, and it can also be found in Article 14 of the International Covenant on Civil and Political Rights. And for Cambodia, we also stipulated a fair trial right concept in the Constitution of Cambodia and the Code of Criminal Procedures and the Code of Ethics for Judges and Prosecutors. And next, I would like to touch to explain why fair trial rights is important. As since fair trial rights has been enshrined in the Constitution of Cambodia, and I believed it's also enshrined in the Constitution of many other countries around the world. Fair trial right is important because it helps to protect citizens of a state, and it is to oversee and to check the state power and to ensure the equality before the law. And in order to protect the citizen of a state or international community, limits need to be placed on the state power. And a state is substantially more powerful than an individual with lots of resources at their disposal. And there was also needs for limits on the state power, which are particularly important in criminal law, because where a state can exert the most power on an individual. And the liberty of an individual, the liberty may be restricted during those times, and there was a fine and even death in some places, and it may be in some places, and death may be imposed on an individual, and there is an incredible burden to be accused or to found guilty of crimes. An individual may be marginalized or unpopular in a criminal proceeding and strict standards. And the fair trial right actually have to rectify this imbalance. There was a principle of equality of arms, and in a sense, this is where we as defense are born from, and the right to a lawyer and the adequate time and to adequate time and facility to prepare a defense and access to information. And of course, perhaps the greatest example of trial without fair trial rights are a show trial, which is an abhorrent to the principle of justice. And I would like to walk you through the duty of defense. Uh, Given my service for 8 years at the defense, I always remind myself that as a member of the defense team, it is for my purpose that to remind to remind it is for my purpose and the role that to remind the court that it is an individual who is on trial, and to remind the court of their right to a fair trial, and to remind the court that justice and the principle of legality should remain central to the allocation of justice, and to remind and to be a, and my role is also to be a voice for my client among the above risk free about among the free. And it is important as defense not to be a fig leaf, simply creating the appearance of legitimacy. There is a case a case in hands for the Cambodian situation, for the Cambodian experience. In 1979, actually, after the Khmer Rouge was ousted, the Vietnamese-backed government actually established a Cambodian Revolutionary Tribunal in 1979 to try the Khmer Rouge leader, and it was found Pol Pot and Ieng Sary guilty of genocide. And this revolutionary tribunal took place only less than 2 months, if I'm not wrong, and with a very limited participations, with an absent of both accused. However, the lawyer of the accused were present, and there were no assessment of the no cross-examination of the witness, no assessment of the evidence, and therefore this revolutionary tribunal is considered as a kangaroo court, as a show trial, because the tribunal did not follow the necessary or the minimum due process, um, as enshrined in any international legal instrument. And again, a defense must actually be effective in its present representation of the client, for example, to be of actual benefit to the client's interest. As I mentioned earlier, for the revolutionary tribunal, there was actually a defense lawyer, but however, the defense was not active and was not effective. So he was like a third factors a defense lawyer, but like he did none of his work. And another instance, Hope Stevens was the victim for the 1979 show trials against Pol Pot and Ieng Sary, advocated for his client clients in absentia guilt. Like I said, because his clients were absent, and he just agreed to the accusation, or he did not scrutinize or did not cross-examine the witness or the evidence put before him. And here I would like to bring to your attention the role of defense of the ECC. And before I start, I would like to bring your attention to the basic principle of at the ECC. First is the presumption of innocence, which was stipulated in Internal Rule 21, and there was a burden of proof on the side of the prosecutor, and there was a minimum standard of proof that the prosecutor have to prove, which is he has to prove his case beyond reasonable doubt. And there were other fair trial rights, which was enshrined in the ECC too, in the ECC law too, and specifically it's Internal Rule 21 of the Internal Rule. And the role of defense and various other organs at ECC is the duty to uphold and protect the client interest, so that it can bring the moral judgment to the victim. And also it has the duty to make sure that the judgments are made objectively, and that that the trial would meet all the due process requirement, and that it would render a legitimate judgment. And as part of my job in the defense team for the pre-trial case, and I think it's also for the trial case, I think this role, or there were some actions that the defense team can take. The first one being that we can file an application for the investigative request to the pre-trial chamber, so that the investigation chamber can carry out investigations in order to bring not only the inculpatory evidence, but also the exculpatory evidence. And we can also file an application of the annulment on the applications, the annulment on the investigation carried out by the investigating judge, or by um, by the previous evidence or finding from the case 001. And our role is also to request for more time and facility if we believe that we need more, and if we can justify that we need more time and facility for to present our case. So in this case, for example, um, my team were given access to case file only um, I'm sorry. So, for example, if when the judge when the judge issue us the any decision and we supposed to file an appeal or respond to any particular decision from the court, when we don't have enough time or enough staff, we can first request the judge for more time and for more facility. um, yes, because we need more, because there were thousand pages of evidence for us to review and in order to file our response. So obviously, and sometimes the decision was issue only in one language for, and usually come up with the English language first, and by the internal rule, by the practice at ECC, any decision or document have to be produced or made in two language, in Khmer and English, so that it deemed that the decision has been served or finalized or final. And yes, our participation is to ensure that the investigation is objective, and during the trial, the defense can do the witness questioning, cross-examination of witness, and evidence assessment, and the scrutiny of the procedure application, just to make sure that um, the due process has been respected throughout the proceeding, and that the fair trial rights of the accused has not been violated. And another key procedure issue at ECC is the principle of the legality. Um, in the ECC law and the agreement provided that the ECC complied the provision of Article 14 and 15 of the International Covenant on Civil and Political Rights, which is the principle of nullium crimen sine lege, or no law, no crime, and the principle of retrospective law, which prohibit the retrospective of penal legislations, and also the principle of the judicial interpretation, which is the judicial interpretation and classification of the elements of an offense that do not violate the principle of legality. And in terms of the fair trial rights standards, there was the principle of presumption of innocence from suspicion to conviction or acquittal. And for example, like the burden of proof of the charge is on the prosecution, and the accused had the benefit of doubt. And no guilt can be resumed until the charge has been proved beyond reasonable doubt. And it is therefore the duty for all the public authority to refrain from prejudging the outcome of the trial. This is the comment in the Human Rights Committee in General Comments number 3. And another standard is the presentation and admissibility of evidence. For example, the exhibit and witness and expert witness. It must be scrutinized and examined and cross-examined by the defense. And there's no double jeopardy, like the case of Ian Seri, the previous King Amnesty, uh, uh, would have limited the ECC jurisdiction on the charge against him. It is not like in the case of Ian Seri, not applicable for crime that he was charged in the Revolutionary Tribunal. And yes, and apart from that key procedural issue, there was also critics of the application of the fair trial rights at ECC. So, for example, in case 004, there was lack access to case file for the first half of the investigation. Um, for example, for my client case, um, we were denied access to case file by the office of the co-investigating judge for the first 4 years of the investigation, and all of the sudden we were given access to case file upon the like just like on the same day that the investigating judge a formal charge against our clients. This denial of access to case file has raised the issue of the right to effective representation because our client um, has been charged or accused of the crimes uh, without any lawyer representing him and without having access to the information of the charge, the nature and the charge against him. And so it raised and it violated his right. It jeopardized or compromised his rights to information as to the nature and causes of the charge alleged, and his right to adequate facility to prepare his defense, and his right to transparent in proceeding. And another um, and apart from that, there was a positive example from the fair trial rights perspective. For example, in case 002/1, one of the accused, Madame Ingtvedt, was found unfit to stand trial, and it's because the trial chamber applied the ICTY Struga test, uh, which read that quote, the trial and continued detention of an accused who lacked capacity to understand proceeding against her or to meaningfully participate in her own defense would not serve the interests of justice, unquote. And therefore, the trial chamber ordered for Ingrid to be released unconditionally. However, the prosecutor appealed the order, and the Supreme Court chamber ruled that she undergo further treatment. And 6 months later, the trial chamber again ordered her unconditional release. And the Supreme Court chambers, following another prosecution's appeal, ordered that she be released but placed under judicial supervision, though placing conditions on her release. For example, she cannot leave the country, and any of her movement have to be reported to the court, and she has to report her presence to the court on a monthly basis. And yes, it's almost come to an end of my presentation. So the last part of it, I'm gonna provide my views and benefits and drawbacks of the ECC. So first, I would like to show you a bit of the benefits of the ECC. The first one is it followed international procedures and respecting fair trial rights of the parties, uh, such as the accused, the victim, and the prosecution. And the court has issued or rendered reasoned decisions, and which was acceptable by the public at large, which was mostly acceptable by the public at large. And it have to build trust on the outcomes, especially on the judgment, and the legal legacy for the domestic judiciary, including practicing lawyers, capacity of judges and prosecutors, and increased respect for fair trial rights, and it's introduced a proper court management into the domestic court, and so on. So in conclusion, the ECC has taken a number of initiatives aimed at enhancing the capacity of the national judiciary and the judicial officials and lawyers, and adherence to fair trial rights and the standard of justice. DCC also contribute to the legal and judicial reform of the domestic court. For example, case management, the legal aid, and the defense. And it's encompassing the separation of power between the executive branch and the court, executive from the court. And there was a greater adherence to a fair trial right, and it also contribute to the promotion of the rule of law in the public consciousness, and it end impunities of the past crimes. And here come to the end of my presentations, and um, and come to the question and answer. And Sandy has sent me a few questions from you, and which I would like to address those questions here. The first question is, you asked me to provide clarification regarding the acceptance of the UN of the Khmer Rouge Tribunal at one point, and also what I understand to be a period, uh, what is understood to be a period when Pol Pot toward the end attempted to reinvent or make his personnel along with his level of responsibility for the failures of the Khmer Rouge during his reign of terror. So this is your original question, which I understand. And if I understand your question correctly, and if I don't understand it correctly, please feel free to address me. But please feel free to correct me and by writing, addressing your concern by email to Sandy. And if I understand your question correctly, you are wondering whether the UN recognized the Khmer Rouge when the terrors, or when the crimes were taking place, and how long this recognition lasts. As you know, the ECC, the Khmer Rouge time was a complicated time in Cambodian history. Internally, the Khmer Rouge operated their business in a secret manner, and freedom of speech and freedom of movement was nearly abolished. And there was no social or economic interaction inside the country. Everything was organized or arranged by the Khmer Rouge. However, internationally, the Khmer Rouge tried to showcase the best society to the world. And during the visit by officials of foreign state, the Khmer Rouge tried to turn the countryside and the worksville into a movie scene with an attempt to depict the best leadership in the world history. Every official visit by foreigners and foreign state had been very under strict control, that which means they can go to only a place that was designated or chosen by the Khmer Rouge. And when the bad records or reporting of what really happened inside Cambodia, for example, there was a report of atrocity, starvations leaked out to the international community. Those reports were challenged by contradiction because every of the Khmer Rouge official reports and the report of the foreign official visit to the country tend to show only the achievement of its regime, while in fact international purge or mass executions started taking place not long after the Khmer Rouge came to power. So the short answer to your question is the Khmer Rouge was recognized as the legitimate government of Cambodia since its inception and throughout until it was outed by the Vietnamese in January 1779, and the Khmer Rouge remained to have a seat at the UN until 1982. And you would ask further why? Why? Well, because at that time in the world, the Cold War was there was how you say there was how you say there was a silent war between the Vietnamese I'm sorry between the Russia and China. And when the Khmer Rouge came to power, China actually supported the Khmer Rouge, and later on when later on the China changed its position to support the Vietnamese. So that's why the China stopped supporting the Khmer Rouge, and it started supporting the Vietnamese government to invade Cambodia. And that's all I think. In a short answer to you is it's the Cold War period. Okay, let's move to the next. I hope I answered your question. Uh, but forgive me if I am not, because this question is such a long, such a big question, and you could do research by reading books and the documents that I send it to Sandy. Um, and you can read the book by Alex Hinton, by Elizabeth Beckers, and by other scholars. Okay, the second question is, there has been discussion on pros and cons of using international tribunals versus domestic court or hybrid tribunals, and whether the ECCC should be purely national or purely international. My short answer is the ECC go a hybrid. That was because the international community was exhausting that funding with the operation of the ICTY and ICTR, and therefore the Securities Council was reluctant to be involved or to take to lead the ECC alone. And so a purely international tribunal is not an option that the UN would choose. And on the other hand, the international community did not trust the Cambodian government to be able to administer this decent justice for this kind of mass atrocity crimes, given the Cambodia, given the fact that the Cambodia lack of necessary legal infrastructure, including the weak judicial system and the poor human resource in the aftermath of the mass killing. And in fact, at the beginning of the ECC, it was known and presented as a hybrid. The ECC was known and presented as a hybrid tribunal. And if you look at the structure, management, and operation of the ECC and the law governing it, namely the UN and Cambodian agreement, the ECC is clearly a hybrid tribunal. The UN and the Cambodian government share the cost and every aspect of the operation and decision making at a 50% share. And however, as time passed by and there was controversy over the government contribution into the expand of the ECC operation and toward the end of the ECC mandates. And also the UN feel that the Cambodian government should take ownership of the tribunal. The international community stopped funding the national side of the court, and even I say stop funding. You you may raise a question. Then why and how it was how the ECC was funded since the beginning? Like in principle, the UN and the Cambodian government agreed to fund the 50% of the tribunal. However, because of I think at that time the government was the GDP in Cambodia was still low, and the Cambodian government was trying to seek funding from individual countries such as Japan, Australia, and a few other countries which I could not recall. So those countries funded the national side of the court, contributed funding to the national fund, and then I think because there was some discussion and challenge by the international community, and also they also feel exhausted with the funding, so they start to um, those the international community start to take away their fund from the national side of the court, but they still keep funding to the international side of the court, and um, the government increased their funding to the court from an in-kind funding, which it support the transportation of the staff, the cover the electricity and the water bills at the court. So it started to put its own money into the court, and all of this was made to understand to make Cambodia the owner of the court, and yeah, and ECC was gradually presented as itself as a national court. And actually, the name of the ECC speak for itself. The extraordinary chambers in the courts of Cambodia. So it means the ECC was function with the national court system, but with support, and where it is lacking or where necessary, it would get expertise or it would consult with the international practice. Okay, I hope again I answer your question. And the third question is what interests me in becoming a lawyer specializing in the field of my practice? Um, this is a very good question, and the question that come to my heart. My journey with my participation with ECC start with my personal journey of growing up. I was born post a few years after the Khmer Rouge. However, I went through civil war, the protracted civil war between the Khmer Rouge troops and the Vietnamese-backed government or the current government. So the Khmer Rouge came to loot my village, and there was not enough food supply in my area, and we have to relocate it from one place to another, um, hoping to find a safe roof. And and what in and what also motivate me to work for the ECC. It's also my first job experience at the Documentation Center of Cambodia, DCCAM, which I got an opportunity to do the research to document the crime, to document the history, or to document what happened at the Khmer Rouge during the Khmer Rouge regime, and where I got the opportunity to speak, to interview, to many victims and former perpetrators, and which gave me and put me in a better position to understand and to see what happened in the Khmer Rouge, as everyone is a victim, no winner and no victim. They are all survivors of the regime. They are all victims of the regime, and it is also my personal life mission and conviction to bring Cambodia to a better place. I'm always proud to speak about ECC. Not that I worked for nearly 10 years at ECC, but for the reason that I have witnessed a standard of justice that I always dream of, and that I start to see that due process and um, yeah, due process and justice actually has been rendered in Cambodia without rendered in Cambodia, and yeah, that a lot of good practice happened in was introduced into the ECC, and that the ECC could do its work in the at least that it meet the minimum standard of justice. Yeah, that's what motivated me to become a lawyer. And actually, I would like to open a bracket before I work for the public interest, but because it has always in me that I want to bring the reform and also to bring Cambodia to another place, because I witnessed myself that Cambodian people, they have suffered too much already during the Khmer Rouge regime, and also in the aftermath of the Khmer Rouge regime. So I think Cambodian people deserved better, and I see my role in it. I see my role in making their world, their country better, even though it's not to the extent that I want, but it is to my best commitment and my best efforts. Okay, the next and the last question is, can I provide personal assessment of the impact of the ECC and the results? Yes, I think we are running out of time. Um, yeah, I think personally the ECC has done its job, and when you don't have a lot of thing, a little any little thing is a big thing for you, and the ECC won't be able to make Cambodia to become a second US or second Germany or a second Japan, but it gave the floors and pave it gave an official floor and paved the way for Cambodia to find a sense of closure, uh, to have a proper floor to discuss their experience, and to have the public at large and especially the young people acknowledge uh, what what happened to them during to them, to acknowledge their suffering, and also for us to have the reason to incorporate genocide education into a formal education, and to openly discuss the Khmer Rouge history, and for the people, for the survivor to heal and to move on, and to give a model to build the judicial infrastructure, and to give hope to the survivor and the newborn generation, and to allow us to know what we can do, to allow us to know that we can do more. And I would like to note that since the establishment of the ECC, necessary improvements have been made in the domestic court. And like I said, when you don't have a lot of things, any little thing counts. And here I would give you, I would like to list down some highlights that that I can put it to you. First is the adoption of the criminal and the code of criminal and criminal procedures, and the adoption of civil code and civil procedure code. Of course, these four laws has been in the drafting process, but I think with the establishment of the ECC, it make it the right time for the law to be adopted. And the second is the adoption of the law on the organization of the courts and the law on the status of the judge and the prosecutors, and the law on the organization and function of the Supreme Council of Magistracy. And like I said, this law has been in the draft form so long, and with the ECC, it is time for its adoption. And this law also guarantee that there is no interference into the administration of justice at ECC, and that the court should be function. The judge and the judge and prosecutor should uh, be performing their duty with independently and impartially. Yeah, and the next improvement is the new court setting. Uh, the new court setting has been introduced. For example, the principle of equality of arm has been somewhat materialized. The access to lawyer for criminal case has been introduced and strengthened. Um, the courtroom setting has been introduced. The as of recently a few years ago, now there is the lawyer meeting room in the prison across the country, while before we don't have. And also there was a lawyer meeting room for the lawyer to meet with their client at the court when they want to discuss or prepare the client before they appear at the court. And also the sitting arrangement in the courtroom, that now the prosecutor and the defense lawyer are sitting side by side of the judge. Before the lawyer has no have no table in the courtroom, so they would sit in the audience seat and to present their case. And another improvement is the access to lawyer for criminal case has been introduced and strengthened, which I already mentioned. And there was a broader recognition of the role of lawyers and fair trial rights in our domestic court. And uh, and I would end it um, with a statement that now people trust the domestic court more, and they have choose the court to settle their disagreement or conflict, and without going choosing violent to settle their disagreement. And this comes to an end of my presentation. And thank you so much for your attention and for your interest in the work of the ECC and the Khmer Rouge history. Thank you so much. I wish you all the best. Thank you.